Welcome, everybody. I'm Patrick Duvaux, Head of Innovation of IMT, and I'm very happy to have you all for the first Webinar-IMTalk. IMT is the #1 higher education institution in France for both startup acceleration and collaborative research with industry. And because of its multidisciplinary expertise on one hand, and international reputation of its work on the other hand, IMT is convinced that it is valuable to regularly share through its webinar IM talks, its innovative insights on important topics for the society and industry. 3 IMT insiders will cast light on skills angles, research angle, innovation angle, and on the other hand, guest speakers will enlarge the views from outside. The first topic of this IM talks will be the Gdpr, General Data Protection Regulation, that will be enforced on May 22nd, 2018. And to quote the EU relevant commissioner, GDPR will disrupt society, business, and more generally, all our digital life. This means it's quite worth to try to understand what are the basics about GDPR, and this is the very target of the IM Talk of today. As a matter of fact, GDPR starts a series of IM Talk dedicated to sustainable digital. Sustainable digital is a new digital paradigm of the society that gives, I should say, finally, the control to the data creator and puts trust at the heart of all aspects of digital life. Let me introduce briefly all our outstanding speakers that will address different aspects of the GDPR, I mean regulation, business, innovation, research, and skills. First of all, Dr. Alexander Duisberg, who is partner and lawyer at Two Birds Law Firm in Munich, will address more or less regulation aspect. And Mark Peter Foskett, who is a GDPR expert, DPO, and serial entrepreneur, investor in reg tech companies, and is on the eve of launching actually specialized reg tech companies on the GDPR. Then we have two speakers, Gwenou Pratouille, who is professor at IMT Atlantic in cybersecurity, and also co-founder of a Watu company, will deal with innovation enablers of GDPR. Javier Franco Contreras, who is CEO and co-founder of Watu, will complete actually the innovation aspect. And Marilyn Laurent, professor on cybersecurity, blockchain, and different aspects related to trust at Telecom Sud Paris. So I give the floor first to Alexander Duisberg, who will answer the tough question: what does GDPR brings to EU citizens?
Well, thank you, Patrick. So obviously wrapping everything into 3 to 4 minutes is a challenge, but if we consider the main objective of the GDPR to actually strengthen the rights of the data subjects and to increase and improve the level of enforcement, we understand that the GDPR is driven to actually focus on the data subject. So every living individual, every one of us here in the room or outside in Europe, to have a stronger position in regard to his personality rights, his data subject rights. We need to appreciate that from the origins of the European Data Protection Directive, going back to 1995, life has become more complex, and you can see that of how the GDPR, now wrapping that into one uniform body of law, has become actually more abundant. And the process leading up to that has been obviously also very cumbersome. We have now a good piece of consolidated law, which is now waiting to be interpreted and to be enacted and to be enforced. And you can see at the very low end of this slide that the level of enforcement is just leaping up dynamically. And if you like, that is obviously one of the key drivers for actually improving the strengthening of rights and enforcement of data subjects. 4% of the global turnover is massive, and this is a concern not only for the very large companies. To wrap it in very short, the fundamental principles and considerations which are built around the concept of positioning the rights of the data subjects to a much higher level are, as listed out here on this slide. Yes, it is obviously a requirement of any piece of law that the processing of personal data in this context must be lawful, must be based on a legal basis. So the GDPR puts in the hands of any data controller and ultimately also of the data subjects the clarity of why and when data may be processed. In addition, a very clear statement comes towards the concept of transparency, informing the data subject, letting the data subject know what is actually happening with personal data that he has put into the hands of a data controller is a paramount requirement which goes beyond what was in the law before, even though it all builds on what was already in the Data Protection Directive. The fundamental key orientation mark is purpose limitation. Personal data must be processed always for a predefined purpose. Now, purposes can be very varied and can be very wide or clearly of different nature, but it is a clear requirement that there must be a purpose which is tied to a processing operation, and that in itself is probably the key challenge and the key requirement under the General Data Protection Regulation. We do also have carried on the principle of data minimization. I personally think that is a little bit in a juxtaposition to, let's say, our reality of big data and so forth. But yes, it is still remnant, as well as obviously storage minimization. So the requirements to keep data only as long as you need it for the defined purposes, and as coming in new, the concept of accountability, being held accountable for what you're doing as a data controller with the data. If we then look at the data subject rights, we can see that we have a few things which were always in the law. Right to access and rectification, yes, that has always been a given. We already had a right to restrict processing, the right to object. The new parts are the right to erasure. Some may remember that there was a Google court ruling around the concept of the right to be forgotten, and right to data portability. These are fundamental rights which are actually impacting organizations that they need to provide systems and concepts which allow to actually give those rights in the hands of the data subject. So massive investment for the controllers ahead, as well as also response times within 1 month to get back to those rights. I think we can only currently guess that we will see the tip of the iceberg of something that will be much more fundamental in how organizations need to respond to those requests. And I think that's it in a nutshell for the kickoff here.
Okay, thanks a lot, Alexander, for this thorough description of how finally a citizen will take control because of the GDPR of their own data. And we switch to Mark Peter Forsket. And this question is probably as tough as the previous one.
Yeah.
Why GDPR is good for business, Mark?
Yeah, the interesting thing, that's what Alexander just mentioned, is going to be probably a lot of job to do for the controller. Nevertheless, we have to focus, just to introduce the subject, is we're talking about the General Data Protection Regulation. I do insist on data protection. That is to say, I think it's a good regulation to fight and prevent massive data leaks and cyber threats. And the GDPR gives the tool to organize the company, the processes, and so on to fit these potential cyber threats. And that is to say that, yes, a lot of responsibility for the data controllers. And what is new, and especially in this country, in France, is that the data controller will have the burden of proof. That is to say, he will have no choice to cope with it and make it. And especially when about the processing activities and the major topic about the impact assessment, how any data subject can be touched, and that it touches his privacy and so on. But we can see it as a positive way for innovation. and make sure that we have tough processes. And I think it will be it would give a lot of room for work, for differentiation, work differently, and do insist on the data quality rather than the quantity. And that has to be, and when we say about the privacy by design, that means that you will have to meet the purpose, but with the less data. So that is very important, really. So I think there is a room for huge disruptions and, as I say, differentiation, but I think it will bring into the company a totally different culture. It's a new culture, really, to impose inside the companies, and by the way, strategy, because we will have to focus on the ethics. And what can we say about what could be the benefits and the value? I think that the DPO is a cornerstone at this stage, and it will be the person who really will help the data controller and the processor to find the priorities and to really organize how we improve the company, but also how we will make money and value the assets of the company. Because once we go through the digitalization of businesses, data will be the major assets. So I think that we have really to consider that very carefully, and that is, I think, when we say, according to the GDPR Article 38, the DPO, Data Protection Officer, should report to the highest management level. I think it really has to also be really enforced and supported by the board of directors, because when the board of directors should really, they represent really the shareholders, and when you're talking about ethics, it touches the reputation of the company, and if something happens, it will shoot the company valuation. So I think the topic has to be taken very seriously. So I think positively it will bring a new relation with the customers, new intimacy, advocacy, and but also it will value the company. So I think trust will drive really huge opportunities for businesses.
Okay, thank you, Mark. This is really probably the second key message. So we're going to switch now to enablers of GDPR. And we understand that if you start after Mark's presentation a new business or a new business model, you have to be to put trust at the heart as a leverage to bring value also to the citizen. Thank you, Mark, again. So we have now, welcome to the program, Javier. So you will explain how more or less you're a brand new technology. I don't say which one, you will say it yourself. That's the suspense, but how your brand new technology that help you to start a company will to some extent help the enabling of GDPR.
Okay, thank you, Patrick. Hi, everyone. So yes, we will talk about Watu. Watu is a spin-off from Institute Mines-Télécom. It results from more than 10 years of research on data protection by means of watermarking. So for those of you who don't know what watermarking is, the basic idea behind watermarking is to hide the message into a document or a data set in order to protect it. More specifically in this context, in order to track it. So the solutions proposed by Watu fight against sensitive information leaks by authorized users. That is to say, people or entities who are authorized to access the information. More clearly, if we take, for example, one first scenario, we have a company sharing data with partners, subcontractors, clients, and so on. So here, in this context, two main questions may arise. How do we dissuade these entities from leaking, from rerouting information? And if one of them decides to reroute information, for example, here we have client A, how do we identify with any doubt this person only from the data? So the solutions what we propose: hide a message, a tag, identifying its receiver into the data themselves at the moment of the export of the data sharing. Then, if client A, for example, decides to reroute to leak information, we will be able to identify him or her by means of this tag. And being informed of the presence of this tag into the data, all the receivers will be dissuaded of divulging, of leaking the information. So in a second scenario, we have, for example, an internal user, an employee, who is authorized to query the company database. In this case, we have still two questions. How do we dissuade this authorized user from leaking query results? And how do we ensure user accountability in the case of information leaks? So as for the first case, what two solutions? Hide a tag into the query results. This tag will dissuade of the user X from leaking the information, will discourage him from doing it. But if he decides to put this information online, to share it illegally with someone else, the tag will allow us to identify him uniquely. So these solutions are independent from the data storage format, as the tags are hidden into the data themselves, and they are robust against most common data manipulations, such as record insertion or deletion, and the modification of attributes values, for example. And these solutions are of interest in the context of GDPR, in particular in terms of data traceability and user accountability. For example, when data are sent to subcontractors for outsourced analysis or storage, they will be helpful for dissuading and identifying misbehaviors when handling or processing the data. So thank you. Now I let my colleagues go on with the presentation.
Thank you, Javier. So we'll understand that, of course, we have a startup company from IMT who is putting on the market, because it's operational today, brand new technology that really can trace more or less clusters of data, and that will dissuade. If you know, when you live in a company, that each time you try to get some data or to tamper them, even to tamper some data, it will be monitored, registered somewhere, and everybody will know it's you. Of course, this is a very good approach and a very good practice, actually, to encourage people to respect privacy.
Yeah, the most important part here is the dissuasion, because it lets...
Thank you, Javier, again. We'll probably have a lot of questions in the second phase of the webinar. And welcome to Marilyn, who will talk about how blockchain can help us to probably do a better job regarding GDPR.
Yeah, so we studied blockchain, and we wanted to use blockchain for support of GDPR. And the first idea we have is to use blockchain to register users' consent and make use of two big properties of blockchain, which are tamper-proof. Okay, and the second one is transparency. So here on this diagram, what you can see is the possibility for a user and a service provider to make a smart contract, okay, to build a smart contract together, to and to, thanks to the smart contract, to make both entities agreed on the contract terms. What I mean with contract terms is which kind of data are transferred from the user to the service provider and under which condition. Okay, so it means which kind of purpose these data are accepted by the user to be pushed to the service provider. After this agreement is made, the terms of the contract are pushed into the blockchain. Okay, so only after the service provider is able to use the data with compliance to these conditions. If in this agreement there is a possibility for the service provider to make some data transfer to another service provider, then this is up to the user and the service provider to make a new smart contract in between. And this smart contract will lead to some information being signed by both and being registered into the blockchain. Okay, so here the second service provider will be able to make use of data, again with compliance to the terms of the contract. So here this is the first possibility of using blockchain for support of GDPR. And also what we have to be careful about is, blockchain is transparent. In case of public blockchain, it means everything can be visible to everybody. So it means we have to be careful that information being registered are not cannot lead to some privacy leakage for the user. So we have to be very careful about what is registered. Okay, and so what we used for making this all privacy preserving with some traceability opportunities for making users' consent verifiable after, like for auditing activities, is we make use of some specific cryptography tools like hierarchical ID-based cryptography, which makes possible the user to generate himself his own ID for the smart contracts, and so he's able to manage itself his cryptography. Okay, and to distinguish one smart contract on one ID for one service provider and another smart contract with another ID for another service provider, just to make sure any transactions done by the user are not linkable from one service to another. So this is the first approach we had, but we also think about other approaches like, the second one is to register and afford access to personal data. So it means we are using blockchain still to register how transactions are managed over the network, and to register authorization being delivered by the user for a service provider to access to his data. So we are using blockchain for both, supporting authentication of the service provider and also supporting authorization for access to personal data. On the third one, we are looking now in research is the possibility to isolate and support controlled linkability between user pseudonyms used by different service providers. What we mean is a user is known as a pseudo, on one service provider, another pseudo on another service provider. And what we're doing is using blockchain to register B2B transactions and to know exactly what kind of data are being exchanged in between. And the transactions are not, linkable. It's not possible to get. So here the idea is to register the transactions between the different service providers, and to make unlinkable, the activities of your user on one service provider and the activities on another service provider.
Well, thank you, Marilyn. This is indeed a very puzzling way, actually, to use the blockchain. We may get some questions later on because there are some paradoxical situations about whether the blockchain is really compliant with GDPR, while here you use it, you know, especially if we look at the erasure issue. Okay, so thanks for all the speakers for the first phase of the webinar, which was to share with you presentations about different aspects regarding citizen, regarding business, regarding innovation enablers, regarding research enablers to appropriate more or less on a daily basis the GDPR. We now enter the second phase of the Q&A, and to everybody, actually, we're going to launch now a survey, a small probe that you can start to answer while we answer the question you ask in the chat mode during the presentation of the speakers. The poll is quite simple, actually. We prepared for you with different experts and outstanding speakers. We prepared 4 issues to be addressed today in the webinar. The first by Alexander regarding regulation, then the citizen, the second for business with Mark, and then Marilyn with research and appropriation, and then innovation techniques, probably unique today worldwide, how more or less to track or to trace clusters of data. So the question of the poll is very simple. Which of these 4 topics fits the most your needs today in your own activity, whether you are in business, whether you are in organization, government, or whether you are a researcher? So these are this is the very simple question you're going to ask now for the poll, and we can switch now to the question you ask in the chat mode. And I have probably the first 2 questions to Alexander. So Alexander, the first question I got for you is the following one. It's very likely that nobody will be fully compliant by the time GDPR is enforced, which will be 22nd of May. Do you think there will be some margin of tolerance?
So very good question. So formally, there's no transitional period. That is in the past. The last 2 years, the wording has been clear. However, it is true and a fair assessment that the lowest number of companies will be fully compliant on the 25th of May. As a result, we are aware that some of the data protection authorities in the member states are also aware of that fact, and they would not issue a formal grace period, but we need to acknowledge that the data protection authorities themselves are also to some extent under-resourced. So it is rather unlikely that severe sanctions may go down on the 26th of May. That said, the data protection authorities have laid out questionnaires, and they will be sending them out to businesses asking, what have you done? Have you prepared well? Do you have a data protection officer? Have you prepared your records of processing? If not, why not? If a company is handing in a blank sheet, that is an unfortunate position, and it is likely to trigger sanctions. The other part of the response is, well, it may not be that every company is immediately on the radar screen of a data protection authority. However, at the point in time that a data breach occurs, and there is a notification obligation towards the authorities, well, that will be the point in time that the data protection authority asks, well, what have you done? Why did this happen? And at the latest, that will be the point where a company is on the spot. And I think we all need to appreciate that data breaches can happen every day. They're typically not announced, and they can hit any company at any point in time. And actually, they do happen all the time anyway. So
if I summarize, actually, more or less, companies, and most likely most of them or all of them, if not all of them, won't be ready, but they will have the burden of proof that they mobilize all the resources they had in their hands during probably between 2016 and 2018, I mean, May 2018, to be ready.
Right.
Right.
And at least showing a good roadmap,
Showing a good roadmap
is very
on how.
important in that regard.
Okay, probably a quick one, which is very much connected to the first question. Somebody asked whether there is a kind of hierarchy regarding the importance amongst all the clauses of GDPR that we should comply with. I mean, if we have to select a few of them, or you consider that they are of equal importance to be complied with, that's a fair question, actually. If I have a small company, I ask myself, well, what should I start from, more or less? So that's another question, maybe a tough one, because nothing is written about this.
Well, no, I think it's a very valid question. As a company, you will need to focus on your core assets, and to the extent your business model is data-enabled, data-driven, obviously you're looking at that first place. I think that's very important to understand. So there's not like a response that fits across the board, but each company needs to look into its own way of operation and then set a list of priorities, what to approach first. Within the parameter of the GDPR, you would try to identify 4 main areas of action. One would be to ask yourself the question, do I need a DPO, a data protection officer? I think that's a very first and foremost question of, let's say, organizational compliance. In the remit of accountability, you would say each company needs to set out a plan for describing its processing operations in the records of processing. This is a clear requirement. And yes, this requires a data mapping. Yes, this requires a larger effort to understand what you're actually doing. And it may well be that you're not fully in line on the 25th of my bit. But again, then you have set a priority of which areas of your business you tackle first, as well as also looking at your supplier ecosystem. Where do you have external service suppliers who are handling personal data? Have you put data processing agreements in place? Have they come your way to suggest updated data processing agreements? That is part of the wider ecosystem. Third area, as I just mentioned before, have a plan to react to data breaches. If the laptop with health data gets lost in a taxi, this will happen on Friday afternoon at 5:30. You have 72 hours to respond. And it is not the moment where you try to find out how you do this. You need to prepare beforehand. You will otherwise be late. This is a very serious issue. And the fourth, and it goes to my presentation from the outset, you need to be able to respond to data subject requests. That's what it's all about. So this may be some companies might say, okay, I can deal with this as I go along, and I respond on an ad hoc basis. By data-enabled, by data-oriented companies, this is not a way of doing it. That requires investment into systems, into processes to get prepared. That would be my quick wrap-up.
Okay, thank you. Yeah, well, that's very useful. Thanks a lot. That's
Thanks.
very, very useful. And I hope it will lower the level stress of some attendees according to GDPR compliancy. Mark, I have a questions for you because we all understand it's just like when new regulation comes up, it's much better to try to natively by design incorporate in your tricks, in your company model, in your software, etc. Right? So I have a question for you, Mark. Do you think, or do you have in mind a kind of framework or model of new business, emerging business in terms of platform that could natively, by design, comply more or less to the most important, the key clauses of the GDPR? I guess it's a very tough question.
Well, it's a tough question, as I've just mentioned in my presentation, and just Alexander just underlined what the importance of the data subjects' rights. So I think we shall focus around the rights of the data subjects, and I think it's going to shoot a lot of current. Some business model that we have today, because when you think about, and there is a question I've seen about kind of business model today about what we could call the horizontal platforms, is how we can call all these business models for companies like Facebook, Google, etc. That is to say that their assets, they leverage the assets of you and me. And quite honestly, what they're trying to do is what we have, from home furniture to electronic devices, pets, and so on, what we do, travel, drive, and so on, and what we know, our colleagues and friends. And the new challenge was, and I say was, on top of this, where does it happen? And I'm afraid, according to the GDPR, that's gonna really be hard to sustain. So because as we said, and Alexander mentioned about privacy by design, and I mentioned it as well, is how do we meet the purpose with less data, better quality, better trust, better, so it will be a higher quality services we have to provide to data subjects, and we have to take to really listen. So it's really new to what are their pains and answer to their pains, rather to push something or just capture their life. So I think there are a lot of business model, a room for differentiation, but being focused around to serve data subjects.
Thank you, Mark. Marilyn, yeah, we started to anticipate actually questions since blockchain is a very buzzy topic, but what is nice in what you shared with us is that you went far beyond and used some functionalities, right, of the blockchain, more or less to comply with full clauses. So we have a questions of an attendee saying that I quote the attendee. I've been told, that's what the attendee say, I've been told that to some extent, thanks to the erasure right, since in the blockchain, it's kind of difficult to erase, right, that the blockchain doesn't really comply with the GDPR. And at the same time, you leverage some functionalities of the blockchain to comply with the GDPR. So there is a kind of contradiction that I'm sure you can clear off for us.
Yeah, actually, you have to think that, yeah, exactly, in the blockchain you can't erase. But what you can do is hiding information into a transaction which is registered into the blockchain. And hiding information means there will not be anything revealed, okay, to some public users. So publicly, there will never be some information, only some very few informations that will be used by auditing authorities just to check that the consent was really approved by the user. But there is nothing sensitive stored in the blockchain.
Yeah, I think that's the point for clarification, because if you don't store any sensitive data on the blockchain, you just because this was the very first, more or less, purpose of the blockchain was to notarize, but not necessarily to store sensitive data.
Another thing is you can also go back to your consent and register another information that you no longer agree on the previous consent you gave to a service provider. That is, you know, it's a traceable consent, but you can, through the blockchain, go back to this consent and remove it. It will be again registered into the blockchain, but it does not mean you erase some traces into the blockchain.
Yeah, it's a dynamic consent. I mean, and this is something new. I mean, previously, when we were asked for consent, it was a one-shot, 200 pages. Nobody read it, right? Now you have to be permanently, right, alerted, and that's called dynamic consent, more or less.
Yeah.
To register. Sorry. Thank you, Marilyn. We have one question for Watu. It's probably to better understand the positioning of your company business-wise, and we all understand that, of course, your business that, does not violate GDPR by any means. I mean, so it's a very different question from the question that was asked for Mark, because the question for Mark was how to design natively, a new business model for platform of services that comply, by design with GDPR. Now the question of an attendee is very simple. I mean, what is What2 business model? What do you sell in a few words?
Okay, so in the one hand, we sell standalone software that allows companies to watermark data sets or documents before exporting them, before sharing them with partners, subcontractors, clients, and so on. So to do so, we provide software licenses for this standalone program. On the other hand, we plan to have a web service where people can upload documents and data sets in order to watermark them and send them to someone else, share with other people. Then we have web licenses. The idea there is that we are not storing data. Data will be sent, will be watermarked, and will be sent to someone else or taken by the data owner. And we also provide installation help and so on. So that's a part of service in our business model.
Okay. So we can tomorrow, thanks to your company, have a website when we can do watermarking of our own data, right, on ourselves, in a very friendly way, interactive way. Yeah, this is very valuable actually, because this increases the control of the data creator on the way they want to handle their data.
As for the second scenario we presented, the idea is to have also software that is completely integrated in the company information system, and that will be sold also with a software license associated to all of it, with a service in order to identify different points where data should be tracked in order to avoid data leaks or
okay. Thank you, Javier. Yeah, we are close actually to hit the end of the webinar, even the second session. So I just kept two, I see crucial questions probably for Alexander. The first one, of course, is not directly related to your field, but it impacts directly your field. Since this question is, do you think GDPR, as it will limit the data collection, will slow down progresses on AI or on machine learning? So it's more philosophical questions and background than the geek question. And then I have another one that enlarged the debate to all the world. That it would be nice to finish actually all the questions on this one.
So to the first question, you could say, well, maybe yes, that's conceivable because processes will be burdened with additional compliance requirements, and they require investment into technology. You can think about the concepts of privacy by design and privacy by default. You can think about security by design, all these issues which actually endorse and are required by the GDPR. However, it's also to be understood that one of the essential key points that the GDPR does offer is, first of all, stepping outside of the remit of the GDPR through anonymization of data, or within the remit of the GDPR to look at pseudonymization of data. So developing technological concepts which actually allow to take out the personal identifiers will help facilitate analytics processes and the development of AI. Otherwise, yes, we need to recognize that privacy is so paramount as a legal requirement that we need to develop AI in consciousness of its impact on data subjects. And for that reason, it is maybe a greater challenge, but it's not something that is mutually exclusive.
Okay, and the second question is very, very tricky, actually. This could be debated in Brussels, probably, or in more international framework. Some very clever attendee says, well, we can expect countries that will be reluctant either to apply the way it is or to try to twist the arm of the EU to change a few clauses. What will be, in your experience, because you have a long experience dealing with international litigations and cases, actually, what is your guess of what will happen and how to handle such a situation? I mean, when countries by themselves, not only companies, even if today some companies like Google, of course, are as strong as small countries. So what is your take of this situation?
Right. So first of all, we need to recognize that GDPR is a European regulation, so it directly applies in each member state without any adjustment or amendment.
Yes.
There are very few limited opening clauses and recognition that, for example, in the field of employment law, in the overlay with privacy laws, there is a recognition of a continuation of, let's say, local regulations, which also do have an interrelation with privacy laws, which continue to apply. However, it is inconceivable that an EU member state would step out of the applicability of the GDPR because it has already been enacted as a piece of European law, and it is now directly effective. With regard to countries outside of the EU, obviously, we see rather more a tendency to consider the GDPR to a certain degree a gold standard, which is setting the thresholds high for other countries to follow. And obviously, given the high relevance of the EU as overall an economic region, it is of high importance for companies out of Asia, out of the US, out of other countries to adopt and be ready to correspond to those needs from the EU so that you can have data-based business throughout the region. So I actually am very optimistic and rather would not believe that there would be a way of withdrawing.
Okay, thank you, Alexander. So I just share with you the results of the poll. I remind everybody that the question that was asked was which of the four topics more or less fits the best your needs. And apparently, which is not a surprise, since the strong message, with the strong message that we wanted to convey in this webinar was how useful is webinar on a daily life. So the majority of attendees actually found answers to that question in what does the GDPR brings to EU citizens. And I think also the disruptive technology of tracing and dissuading people from tampering or trying to steal or to leak data, because this is really a unique technology puzzle, many attendees. So I'd like, after this, to thank all the speakers, Marilyn, Javier, Mark, and Alexander, and also all the people that were behind to make sure that this webinar went through smoothly. I thank all the attendees. And according to our talks today and our thoughts, we envision that the second webinar dedicated to sustainable digital will be dedicated to ethical artificial intelligence and will most likely take place at the end of September or beginning of October. So thanks again, everybody, and see you for ethical AI. That will be the IMTalk #2 of Sustainable Digital.